right, hello and welcome to another episode of A Question of Law. Here we break down the law as regards our various, issues that are happening in our lives, discourses that go on in our daily activities and so on and so forth. And we try to help you understand what the law says. Today we're going to go back to something that's somewhat basics, how laws are made. When I come back, I'll introduce my guest to you and we'll get into this conversation. Let's take a quick break. All right, welcome back. And my name is David Kwekusechi, and my guest here, Salam Adunu, who's a private legal practitioner, as well as Clementa Kapam, also a private legal practitioner and a senior law lecturer at the Gimpa School of Law. Gentlemen, welcome once again.
Thank you.
Thank you, Kweku.
How are you doing today?
We are great.
Well. Good,
Guess
good,
you're well
good.
too. Hope you are doing well too.
Yes, very, very well. Thank you. So, how did we come by the law in the first place?
How do we come by the law?
Yes.
We have to go to the days of Moses.
Okay.
So Moses got the law. It was on a tablet. We had the 10 Commandments.
I
That's law,
remember that,
actually.
yes, exactly.
Oh, were you
from
there?
the scriptures. From the scriptures, from Sunday school. I remember that.
So, generally, society over the time will come up with rules and regulations to regulate how we interact. Because once there's interaction, there's bound to be friction, there's bound to be people stepping on each other's toes. So once there's interaction of human beings, so society will come up with various ways of ensuring that we live in a harmonious environment.
Okay.
So the reason why you have a law that says do not cross the red light is because it's not because the policeman does not want you to drive top speed, but because he must stop for another person to also pass. There are others who do not have cars and who want to cross the road. So laws are made to regulate our day-to-day activities. So that's how, and the 10 Commandments and the Torah tell us to regulate how we relate to God, and that is where you can trace
that's where laws
the
come
footprints
from.
of what we're talking about when we're saying law. For me, I'll trace it from that
point.
So rightly so. So laws are generally put together to regulate human activity or to regulate society. You can imagine a society without laws. Everybody does what he or she wants, and that will result in an anarchical situation. And so laws will regulate activity. So human beings sleep, wake up, decide to do something. There should be a way the system must sit to say, okay, this is what people are doing. Is it right? Is it wrong? Now, whatever the decision is, we must regulate it. So just to give an everyday example, so mobile money. Many years ago, there was nothing like mobile money. So there was no need for any law to regulate mobile money. But so it started. The system had to realize that, people are transacting business this way. If we don't regulate it, things may happen that would not be appropriate. So let's put in a set of laws to regulate that. People want to marry. People want to marry. You must put in laws, or there must be regulations in place to regulate how the marriage will be and how they can get together and marry. People want to divorce. People are marrying, yes. People want to divorce.
They want to end the marriage.
They want to end the marriage. We must put in law or a regulation to guide how the divorce or the separation will be. So laws are very important. It's meant to regulate society, and we can only imagine a society without laws.
So are there processes that we go through to enact laws? What's the general thinking? How do we come from a place where there's no law because it wasn't needed to the point where now the law exists? Are there processes? Are there conversations? Who initiates these things? Because I know that we call the House of Legislature as the Parliament. Are they the only ones? Can somebody else, get involved?
So very, very intelligent question, Kweku. To even get to the point of how the law is made, we must first try and understand the types of law.
Okay.
Because the type will determine how it's made.
Oh, okay.
Because not all laws have the same strength. Not all laws are made by the same institution or entity.
Okay.
Or not all laws are made the same. So depending on the type of law we're talking about, then we will know how it is made. So what comprises, if we take our space as Ghana, what comprises the laws of Ghana is heavily regulated by the 1992 Constitution, where in the Constitution, in that famous Article 11 that every law student knows. That's the first thing you will know when you enter a law class and you're taught constitutional law. Article 11 will come to you.
Then I better learn Article 11.
If not already, I thought So in Article 11, it will give you the laws of Ghana. And it will say that the laws of Ghana will comprise of, and they will give you a list. So the Constitution, it's the law of Ghana. Enactments made by or under the authority of Parliament established by this Constitution. So we have the Constitution
itself.
It's law. Enactment made under the authority of Parliament as established by this Constitution.
Yeah. Okay.
Then it will go on to say any orders, rules and regulations made by any person or authority under a power conferred by this Constitution. Then it will say existing law, meaning there was some law before this Constitution. And then the common law, also another class of law. If you read further in Article 11, it will also mention customary law. If you read the Constitution and you get to the part on decentralization, it will mention bylaws. So if you take the totality of the Constitution together, when we say what comprises law, the Constitution itself is law, the enactments made by Parliament is law, the orders, rules, regulations is law, the existing law, the common law, customary law, and bylaws. So we say that within this list, there's a hierarchy. So the Constitution is
top,
primus inter pares, sits at the top, and all other laws must take their strength from the Constitution. So you cannot have a customary law rule that sins against a provision in the Constitution. That customary law rule will be held to be null and void and of no effect.
Wow.
You cannot have Parliament pass a law that breaches a provision in the Constitution. So there is a hierarchy. And the hierarchy also shows the strength. So if someone is quoting a provision in the Constitution to defend or to support a certain position, you cannot quote a customary law rule or a rule in an act of Parliament as basis of your what? Opposition. So this is the starting point. And you will see that in Article 11, it will indicate under the authority of Parliament by a person authorized. So different persons will be given the power to make different types of laws. The commonest is what we'll see being the Parliament, giving the power to enact legislation in the form of Act of Parliament. And that will have a process that will start and culminate in the assent of the President to the law. So ordinarily, these are the types that will exist, and depending on the type, we will know the process. So we can take the types one after the other and try and look at the procedure. But the most common that everyone will know that comes to us daily is what we see Parliament do by passing laws in Parliament. And actually the one that is also very close to us is customary law. In every community, in every village, there's one law that says you can't go to the farm on Thursdays.
Okay.
You can't go to sea on
Okay.
Tuesdays.
Okay.
You can't do the. It's not written anywhere. It's customary law. Break that law and you will see the consequences. So that also has its authority and who can make such laws.
Okay. So I don't know what you want to say.
Yeah, so generally, that's the position. And Article 11 is a very popular provision of the Constitution with many people, law students especially, and lawyers. So Clement mentioned the issue about common law. So we have the common law as it is, which is a body of law in common law jurisdiction, UK or England especially. But the definition of this common law, as we see in our Constitution, is that the common law of Ghana shall comprise the rules of law, generally known as a common law. Ghana is a common law country. And the rules generally known as the doctrines of equity. And so the doctrines of equity were formed to assist in the adjudication of cases in a manner that showed a lot more human face, which was fair, fairer, etc. Because the rules of common law itself were deemed to be a bit rigid and sometimes, hard-handed on certain situations. So the rules of equity were then formed. So we have the maxims of equity. He who comes to equity must come with clean hands. Equity follows the law, etc., a number of them. The rules of customary law, including those determined by the Superior Court of Judicature. And it goes ahead to say that for the purposes of this article, customary law means the rules of law which by custom are applicable to particular communities in Ghana. So this essentially distinguishes our common law from the common law as we have in England, for example. Because in the common law of England, you don't have our kind of customary law. Clement mentioned, go to some communities, you don't have to do this at this time, you do it, there are consequences. We talked about personal law, etc., before. And those things form part of the customary law. We had our own rules or laws many years before the white man came. Those rules and law were customary in nature. When something happens, the chief must come in, the chief must do this. All these form a body of what we call customary law. They are customs. And it will not be fair on us for us to have thrown all of these things away, because there were rules we were living by, which were helping us before the white man came with all of these. So these have been incorporated into our general law as part of the common law. So those rules are very much alive today once they do not sin against the Constitution. So, for example, I don't even know if the matter of female genital mutilation could be something which we can say is part of custom. Of course, it could be part of custom, but now it is frowned upon because it breaches or it goes against the Constitution generally, human rights, etc. Exactly. So matters of female genital mutilation, though it was allowed by custom in those days, now because of the superiority of the Constitution, which has within it at chapter 5, which has human rights, etc., doing those things, go against the human rights provisions of the Constitution. So female genital mutilation and other, cultural practices which are bad, which are demeaning, widowhood rights, etc., which may be customary, but are demeaning to the person, will violate the dignity of the persons. Those ones the Constitution frowns upon, so those ones cannot be allowed. So that is how we contextualize our customary law vis-a-vis the Constitution and other laws.
I've heard you use these terms. Common law, customary law, are they the same thing? Where do they intersect, if they do?
So there's a common law, the common law of England, and many countries that took inspiration from England, or many of the countries that were colonized by Britain.
Would you say common law is largely unwritten, or it's documented?
So common law, yes, it could be largely unwritten, but we have portions largely unwritten. But in our situation, we've had a lot of them now codified to become law, properly so called. And so same as the customary law, they are generally unwritten, but they are laws. For some reason, some of those customary laws will have found a way of getting codified in various documents, and they become law. But whether codified or not, once they are law and recognized by the Constitution, they continue to be law.
So if we were to look at you mentioned taking the types one by one and looking at them. So let's start from the bottom up. I don't know if that makes sense. And say that we look at bylaws, and then we look at customary laws, and then we work our way upwards.
Right, sounds good. So, the bylaws, the power has been given to district assemblies, and these assemblies here will include the municipality, the metropolitan. So, district is used so the district assemblies are given the power to pass bylaws. Now, these bylaws will be jurisdictional. So it is within and operates only within the boundaries of that district. And these bylaws are to ensure that the district, events, activities, the socialization within the district are regulated within certain limits. Now, these bylaws cannot be made for events or situations that have already been regulated by a higher law.
Okay.
So the bylaws, maybe, recently we heard in the news the district assembly passing bylaws on certain dress codes for certain category of females within the district, because there was a high report of teenage pregnancy, and so they took certain steps. So these bylaws are at the district level, and they operate within the boundaries of the district. And it is the district assembly, on the authority of the district assembly, they have the power to pass these bylaws.
Okay.
So that's the first one.
Okay.
Customary law, as the name implies, it's custom. And who are the custodians of our custom? A traditional authority. So the traditional authority are the custodians, they are the interpreters, and they are the enforcers of custom. So if we disagree that a certain custom exists, first off, it will be at the instance of the custodian of custom, being the traditional authority, to be able to tell us whether or not this is the custom. If we think that that custom is repugnant to the Constitution or to certain acts, then we challenge it at a higher level. But customary law is the preserve of the traditional authority, where traditional authority will give directive as to which customs are available, or which customs have been in quote unquote enacted, because mostly it's oral. It is transmitted by oral tradition that is unwritten, but very well known and very respected.
Okay.
Even though it is oral and unwritten. So it is the chiefs or the chief in council or the traditional council who will be vested with the authority, because they are the custodians of the custom, so they will be charged with making customary law. And that is also jurisdictional. So a customary law applies to a particular community.
Okay.
So you might have similar customary laws, but it doesn't mean that it is universal.
Okay.
Customary law applies to particular identifiable community. So then the traditional authority will have the power to enact customary.
Okay.
So bylaws, district assemblies, you go through the process within the assembly meetings to receive a proposal, they'll study the proposal, maybe there's an event that needs regulation, or there's an activity that is becoming pervasive in the community that needs regulation. There's no national law regulating it. It is only particular to that community. It is very district specific. The assembly will discuss it in their meetings. It's passed, and then it becomes law.
Okay.
So the customary law, very important. And sometimes the court relies on the traditional authority to assist them come to a certain conclusion or in determining a case. So there's this case where in marriage or in a matrimonial case or a family law case, where the court had to determine whether the two persons were indeed married, because one was claiming she was married to the man, etc. The man said no, or the man's people said no. The court then had to write to the House of Chiefs, I think the BA Bonahafo then House of Chiefs, to let the court understand what the traditions of the place was. So the House of Chiefs sat, put together a comprehensive document and sent it to the court. And based on that information from the traditional authority, which form who are the custodians of the traditions and customs of the people involved in the matter.
Yeah.
The court was guided or aided to come to a certain conclusion. So customary law and its custodians, very important in how laws generally operate in Ghana.
All right. Well, let's take a quick break. We'll be right back, and there's more to come on a question of law.
Citi TV is live. On DSTV, go to channel 363. On GoTV, access Citi TV on channel 182. On a digital TV, please press the menu button on the remote control and run a new search on your TV. Take note that without an antenna, you cannot access Citi TV on your television. Citi TV can be accessed on a free-to-air digital box like the GoTV and Star Times box. Citi TV, it's your world.
All right, welcome back from that break. We're discussing how laws are made, and one of the things that fascinates me is the whole hierarchy of laws. Now, Clement, I wanted to come back to you. You gave the breakdown and said the Constitution is at the very top, and then there's the enactments of Parliament. Then there's more to come. But we started breaking it down as to how laws are made, and we started from the bottom up. We're saying that we're looking at bylaws, we looked at customary law. What's next in the hierarchy going upwards?
So in going upwards, the next step will be your orders,
okay,
your rules,
okay,
your regulations.
The existing law.
Existing law. So that's one step before. So the existing law is the law existing before the coming into being, because the Constitution will have to adopt.
Okay.
Otherwise, then all those laws will cease to exist. So we give savings to the existing law.
Okay.
So that's the law in operation before Constitution 1992. So that's why you can see that we'll still be referring to
1960 something.
the Sale of Goods Act,
yeah.
1960. We'll be referring to Bill of Exchange Act, old laws in 1961, 79, 74, existing law, adopting.
Yeah.
Then after your existing laws will come
the orders.
So the existing law is made already.
Yeah.
So it's either existing law made by a previous parliament or existing decree made by a previous military regime. And sometimes also the names of the law can tell you whether it was made by parliament or was made by a military regime. So if you hear a decree, it's military regime. So in our law, if you hear Armed Forces Revolutionary Council decree, even the name tells you an armed forces. But if you hear, for instance, Sale of Goods Act, or if you hear PNDC Law 111, was made during the PNDC era.
Okay.
PNDC Law 111. Okay. So the names will give you an idea also of type of regime that made the law. So that's existing law. Basically, what was in existence before the Constitution came into. Then we'll get to the next on the ladder being rules, orders, and regulations. So rules, orders, and regulations would take their strength from acts of parliament. So there, parliament would have given the authority to a certain ministry or a certain agency to be able to make regulations. And these regulations are in itself rules that will help in the implementation or operationalization of provisions in an act of parliament. So your regulation is like your technical guidelines.
Okay.
So if the Act says don't go to the market on Sundays, the regulation will say on Sundays between the hours of 3 and so it will give the more
breakdown.
technical operationalization of the provision in an Act of Parliament. Or the regulation will now specify or give more meaning without derogating from what the Act of Parliament sought to regulate. So those, and then others also you will see, for instance, we have our rules of courts, the rules that will regulate the procedure in our court. At the High Court, at the Court of Appeal, at the Supreme Court, these will form part, and there are institutions that have been given the mandate to make these laws.
Okay.
Now, within this band as well, you can read, it says any orders and rules. So you can read into it rules made by constitutional bodies that have been given the power to make rules.
Okay.
And for instance, they will make their rules in the form of constitutional instruments.
Okay.
So
CIs.
Currently, there's news on CI, the Electoral Commission, body set up. They've given the power to make rules to regulate our elections. So they will determine the rules. But the constitutional instrument does not become law unless it goes to Parliament that has been given the power. So legislative power will still rest, but then the CI will have to go through Parliament as part of the process of becoming valid law. So within that band of orders, rules, and regulations, you will have all these coming in. During the COVID time, we also heard about EIs, executive instruments. You can put them all. So the executive instrument is the power, and as the name implies, it's an executive instrument as opposed to a legislative instrument. So a legislative instrument is an instrument from Parliament. Originating on the back of an Act of Parliament. An executive instrument, on the other hand, is an instrument originating from the executive
arm of government
on the back of a legislation giving it power to issue executive instruments. So during COVID, we'll pass the Restrictions Act, and on the back of the Restrictions Act, there will be powers given to the president to issue executive instruments and then to regulate portions of activities that will happen during emergencies, during the COVID pandemic. So all those types of, for want of a better word, little laws we will find in that band that says any orders, rules, and regulations made by any person or authority under a power conferred by this Constitution. So that's where they will take their power from.
So yes, rightly so. So in the body of the orders, rules, and regulations, you can see that a lot of things happen there. So now we are having a conversation about CI, constitutional instruments. So in that case, the body, bodies which have direct or that power is directly taken from the Constitution. So, for example, the Constitution says the Electoral Commission shall, through an instrument, make laws that will govern our elections, the conduct of our elections. So, by that, it means that the laws put together, the rules put together, will have to come to Parliament. Come to Parliament, rest in Parliament for 21 sitting days. MPs have very little to do about that. They just have to see it, and they are the representatives of the people. They must know what is coming. However, if they see in that law something that is against the Constitution or that flouts the Constitution or things which are not proper, they can call the attention of that body to deal with it. They cannot on their own deal with it. They can either annul it or pass it or approve, get it approved. What they have begun to do, what they have done in recent times, which provides them some convenience, is to have what we call the pre-laying debate, where a lot of issues about it will be debated. So, for example, in the current CI, we are looking at the Electoral Commission CI, which seeks to use the Ghana card as the only means of identification for getting onto the electoral roll. They've had debates, pre-laying debates, where a lot of these matters we are hearing, have come up. So if these things, if they are unable to reach a consensus, they have to take it back to, a consensus to say, okay, we don't want this, we want that, for the EC to go and relook at. Once it is laid, and you count 21 days,
question of time,
it becomes law. That is why you can see a lot of the minority people, fighting tooth and nail so that it doesn't get laid. Once it gets laid, it just becomes a matter of time. It becomes law. So without the Ghana card, you cannot get onto the electoral roll to vote as as a citizen, or vote as somebody in Ghana who is interested in helping shape the direction of the country. So from that, we have enactments by or under the authority of Parliament established by this Constitution. So that is what we call the Acts of Parliament.
Okay.
So, for example, Act 29, which deals with criminal offences, etc., that is an Act of Parliament that was enacted in the first Parliament of Ghana.
Okay.
A number of laws get enacted almost on a daily basis. Recently, the Companies Act, was enacted. The old one repealed, and the new one, we have it now. So Parliament has that. And there's a whole elaborate process of Parliament doing that. I think if we have time, we'll go into that. After that, you get to the Constitution, or to turn it around, the Constitution becomes the first, Acts of Parliament second, and then the orders, rules, and regulations come third, and then the existing law, and then we have the common law, which we've explained. So the Constitution is the basic law of the land, and you cannot have any law that stands in conflict with the Constitution and remains. Once it stands in conflict with the Constitution, that particular law will have to be struck off. So, for example, when you look at Article 1 of the Constitution, Article 2.1 of the Constitution, it says a person who alleges that an enactment or anything contained in or done under the authority of that or any other enactment is inconsistent with or in contravention with the provision of this Constitution may bring an action in the Supreme Court for a declaration to that effect. So what it means is that when you bring this action to the Supreme Court now from Article 1.2 says that the Constitution shall be the Supreme Court of the land, and any law found to be inconsistent with any provision of this Constitution shall, to the extent of the inconsistency, be void. So it means that any law at all that operates in this country must be in consonance with the Constitution. You cannot have two laws being in conflict and the two laws operating at the same time. Okay. So what it means is that once you have two laws in conflict with each other, the lower one will have to be struck off. Yeah. The lower one will give way to the Constitution, because the Constitution is supreme. And there's a whole process also of getting the Constitution. Even if you want to review it, there's a whole process of doing that. So that is how our laws really are. And by that order, like Clement says, if I'm making a point with the Constitution, you can't use as an inferior law to want to fight against that. The Constitution is supreme. So all other things must defer to the Constitution. So every now and then you hear people go to court to strike out provisions of Acts of Parliament. So recently, Martin, people went to court on this matter of bail and struck off of section 96(7) of that law, which says that some offences were not bailable. Offences around drug, murder, and things like that were not bailable, which meant that if I accused you of having peddled or having killed somebody, etc., once that hangs around your neck and police arrest you, you cannot be bailed. And he went to court to say that was against the liberties, the freedoms of liberties, etc., that the Constitution gives. You proving, you are innocent until proven guilty and all those things. So on what basis would a person continue to be in custody? That is punishment. So the Supreme Court looked at it, saw it, and realized that no, that's right. They had to strike off that provision in the act, in the act, which meant that act, worked against the Constitution or was in conflict with the freedoms of liberty, etc., that the Constitution guaranteed. And so that had to be struck off because it was now null and void because it sinned against the Constitution. That is how superior the Constitution is in all the laws. That's why we say that it ranks first among the hierarchy of laws or in the laws here.
Yeah. So we've exhausted the types.
Yeah.
But there is one arm of government or one arm that the Constitution creates that will make laws that we are not seeing here. So we have what we call judge-made law. And there's contention whether it's actually law or it's... For instance, if the Supreme Court takes a provision of the Constitution and interprets it in a form that, if you read the Constitution, ordinarily you won't see it there, that's making law.
Oh, wow.
So, during the election petition, if in the election petition, if the Supreme Court defines what it thinks overvoting is, that becomes the law on overvoting. If I'm looking for the law on overvoting, I will quote the election petition case, and I will quote that definition.
There.
Yes.
Okay.
So that's judge-made law. But judge-made law will only arise when the one pronouncing has judicial authority to make those pronouncements. So judge-made law is also an area. I mean, in our Constitution, when it comes to the removal of Chief Justice, for instance, if you read the Constitution clearly, you will not see the requirement of an establishment of a prima facie case in removing the Chief Justice. But if for other justices of the Superior Court, you will see the requirement of the establishment of a prima facie case. Our Supreme Court took a case that was brought before it and then read into the provisions of the removal of a Chief Justice a requirement for the establishment of a prima facie case. But if you read the provision as we have it currently in the Constitution on the removal of a Chief Justice, you won't see that requirement.
Okay.
But so that is judge-made law, and that's law made by the Supreme Court, because the Supreme Court has been given the power by the same Constitution to interpret it. So when they interpret it, their judgments are as good as the provisions in the 1992 Constitution. And you can use their judgment also as a basis to support a certain legal position or to say that a certain activity cannot happen.
Yeah.
So just to add to that,
yeah,
so where, for example, there is a gap, in the law, and the matter is tested in court, or something happens, the law is not clear on it, and so you go to court, the court takes that opportunity to fill the void or to fill the gap. So, for example, Article 22 2 talks about the fact that Parliament shall, as soon as practicable, after coming into force of this Constitution, enact legislation regulating property rights of spouses. Property rights of spouses. To date, this Constitution is almost 30 years old.
I want to give you another one. If you are mentioning 20, so let me give you another one. Okay. Article 1815. It's there. And it's my pet peeve. Article 1815 on international business transactions. It's there. It's also 30 years. Nothing has been done. And we are hoping that Parliament will take the opportunity to do that. If you look at 1815, it says, this article shall, with the necessary modifications by Parliament, apply to international business or economic transactions to which the government is a party to as it applies to a loan.
So
30 years.
So what it means is that there's a gap. Parliament hasn't done what it has to do. So this spousal, this property rights of spouses law that Parliament must enact is still in Parliament, because there are issues around what happens to concubines, somebody you've lived with as a person, become a part owner of your property, all of that, and you can understand. There's a lot of debate around it, and so that law is shelved somewhere. But the Constitution says Parliament should do that. But the issues arise, in society, which require solutions. But the solution should have been in this enactment Parliament was supposed to have done. They've not done it. The matter goes to court. Should the Supreme Court or should the court sit and say, because it's not been done, we don't have a solution? No. The court must find a solution. So the court now solves the problem using the laws. So once that problem is solved, that becomes law. And that can be applied to various legal positions, and it solves problems.
Okay. So, you know what? I think we're going to have to do, a part 2 of this conversation because recently the president made a comment when the vice president of the United States, visited and said that was a private member's bill. I want to understand private member's bill and how that comes into play, right? And then also, of course, when does the president sign off certain things,
if he refuses to sign, what happens?
What is pre-parliamentary, parliamentary, post-parliamentary? I want to, we have to get into all those things. So
definitely.
we definitely have to have another conversation on how laws are made. But now, the docket is up next. Don't go anywhere.
Citi TV is live on DSTV. Go to channel 363. On GoTV, access Citi TV on channel 182. On a digital TV, please press the menu button on the remote control and run a new search on your TV. Take note that without an antenna, you cannot access Citi TV on your television. Citi TV can be accessed on a free-to-air digital box like the GoTV and StarTimes box. Citi TV, it's your world.
All right, welcome back. It's time for the docket. And today, this one here says, hello, a question of law. My marriage is no longer working, and my husband and I have agreed to go our separate ways and consequently divorce. My husband, who was going to file for divorce, came asking that we do it together to avoid a situation where he will have to compensate me. I don't really have a problem with the divorce, but I want to know the legal implications of such a step. How can the law help me? Yeah. I think you made mention of this in an earlier episode.
Yes. So divorce. Divorce is one of the things that life sometimes comes with. So there's marriage, and marriage is you don't put it asunder. Nobody, what God has put together, let no man
put asunder.
Yeah, let no man
This
put
is
asunder. Yes.
Let's take that.
But human beings themselves try to put things asunder, but that's fine. So the law again must find a way of regulating that process. So what the law is saying is that you cannot have a divorce until it is established that the differences you have, are beyond reconciliation. That's the cardinal point. So the differences you have must be beyond reconciliation.
Yeah.
And how do you come to that conclusion? You can say, because this person committed adultery, I can no longer live with him because it's beyond reconciliation.
Yeah.
For me, it's beyond reconciliation. We cannot. I cannot deal. Yeah, I cannot deal with that. There could be cases of desertion.
Yeah.
The person has deserted you for a long time, etc. But the omnibus, ground offering is unreasonable behavior, because the person has put up or is putting up an unreasonable behavior. I can no longer, be in the marriage. Our differences are irreconcilable. Okay. So once that point is reached, then now we can begin listening to you. Now this is saying the person is saying that the husband wants them to do it
Joint
application.
Joint application, so, because of reasons of how do you call it, compensation.
Yes.
One person has to file, but for the two of you can agree that you want a divorce. That's done. That's a decision that the two of you come to, and the law will help you, break it apart. So one person has to file. One person has to be the petitioner. Then we'll have the respondent. Issues about compensation, whether compensation or not, can be determined by the court, or the parties can say that for A, B, and C reasons, we decide that each person will go away with whatever. Sometimes in the process, the parties not wanting to wash their dirty linen outside can say, these are the facts. We want to go our separate ways. but we have decided or agreed that properties we acquire together, this is how we will settle each other.
Yeah.
So maybe we have 2 houses. We give this house at cantonments to the man. We give this house at Laboni to the woman. We share it, and we distribute the property amongst ourselves. We do it in a terms of settlement format. We present it to the court. The court looks at it, and the court adopts it. Yeah. Once the court does that, the court now goes ahead, maybe takes evidence from the parties, and pronounces the marriage dissolved if the court is satisfied that indeed the marriage is broken beyond reconciliation. So the matter of compensation, if the parties are not agreed on how the properties be distributed, the court will have to take evidence and make a determination on how the property will be distributed. Okay. On the matter of compensation, the court will look at the party with the bigger means and say that for A, B, and C reasons, you compensate this person, or you give this amount of money or alimony to this person. So if the parties themselves agree on something, the court will look at it, and the court could give its blessings and adopt it. If they are unable to reach that conclusion, the court will have to help them reach that conclusion. So I'm not sure about the person saying that because the husband wants to avoid compensation, he wants them to do it together. Yeah. If the two of you can agree that I want a divorce, but you can also say that because you are richer or you have more money than me, or maybe I'm likely to be a bigger loser in all of these, you compensate me. Yeah. If you don't agree, you take it to court, you make your case in court, the court will look at the evidence and really see the means, call for affidavit of means, etc. Yeah. See what you earn, see the expenditure, see all of that, and then make a determination as to who gives who money. Even before that, we have maintenance in the subsistence, or whilst the divorce proceedings are going on. One party can come to the court with an application that I want to be maintained. Often it's a woman who do that. That because the man was my husband, he was the one taking care of the home, etc. With this process, he's not taking care of me again. So I want the court to make an order that he continues, or in this case, he or she continues to maintain me. The court will look at the means of both sides and see how you were living before, and make a decision that give X amount of this money to this person every month until the case is fully determined. So I'm not sure it's for the person to say, because I don't want to pay compensation, I want us to do it together. They must have a discussion, and that discussion should end or conclude whether indeed one person has to compensate the other or not. You can't try to be too smart about it. She doesn't. She has to open her eyes. She has to shine her eyes. As we say.
She has to get a lawyer.
I'm surprised that. Anyway, I guess it's just a general discourse in society that says that when you are, or we think, people who are not lawyers, we think that if somebody applies, they will have to compensate the other person.
No, I mean it's the nature of our judicial system. It is assumed that the one who takes the first step, is the one who is right. So the plaintiff, he takes his case to court. Now you have to go and defend yourself. Our judicial system is adversarial in nature. So there's always someone who will come as plaintiff and someone who will come as defendant. In a matrimonial causes action for divorce, there's someone who must petition. You might be the one who is saying that I don't even want it, or you might be the one who wants it, but there must be a petitioner and a respondent. So you cannot have, it's not, divorce is not one of the things that we can use alternative dispute resolution, ADR. I mean, maybe
that's pre-divorce.
At custom, you can do that. But
to see if you can resolve the matter.
To resolve the matter. But if it is to dissolve the marriage, and if it is an ordinance marriage, there's a way of dissolving it. If it's a customary marriage, there's also a way of dissolving it. So if you're going to court, then it presupposes that it's marriage at ordinance, and that is the court that has the power to dissolve it. And someone must petition. And as Selom explained, in your petition, you can decide that, yes, reliefs. What reliefs are you seeking in your petition? We do not intend to seek any reliefs. We want the marriage to be dissolved for us to go both ways. That will show the mutuality of intent. But if it is for the purposes of not compensating, are you going to both walk into the court and say, please, we all agree that we should go home? No, that's not it. It doesn't happen like that. Yeah.
So the other point to make quickly is that the fact that we have a lot of people in very toxic marriages, they want an out.
Right.
But they think that if they initiate the process, it means that they will have to, or they will lose out.
Yeah.
It is not the case. If, for example, my spouse is beating me and my life is at risk, I do not have to keep staying in that toxic marriage.
Situation,
I may die. If I go to court, and a lot of people are trapped in marriage because the women especially, they don't have the economic means or the financial means. And the men know that, so they use that against them. If you go to court and you seek a divorce and the man has means, you will benefit. You will get what is due you in the marriage. In an earlier episode, we talked about spousal property and how that is shared. You will get means. The man, if he is the stronger one financially, will have to compensate you or pay some money. The court will determine that if the two of you are unable to come to some agreement. So it doesn't matter whether you initiate it or not. What will be done will be done. The court will look at the case on its merit and then deal with it. Often, the one, should I say the aggressor or the one who causes the problem is not the one who takes the matter to court.
It says the aggressor.
It is the aggrieved who often takes the matter to court. So it doesn't mean that if you take it to court, then it means that you are the cause of the problem. Anybody could take it to court.
And I think that's a very good point that viewers will have to take away, that if you take the first step, it doesn't mean that you're right or wrong. Particularly in relation to divorces, because as explained earlier, you agree that the marriage is broken down for certain reasons. So based on that, either male, female, husband, wife can take the first step as the petitioner, and then the other will respond. But if it's mutual, then it's a non-contentious divorce. So, and normally with divorces, once you file your application, the court will give you 6 months to go and try and see if
figure
you can
yourselves out.
Yes.
If
So all that will exist. But if it's a mutual thing, it shouldn't be a problem. But
fantastic.
One must take the first step.
All right. Well, let's take a look at today's legal trivia.
Legal trivia. Did you know that where a woman is convicted of a non-capital offense, the court must first order that woman to be tested for pregnancy, and when she tests positive, the court must give a sentence other than taking her to jail, or the court can even suspend the sentence. This can be found in Section 313A 1 and 2 of the Criminal and Other Offences Procedure Act 1960, Act 30. Take note and do the needful. That will be all for our legal trivia today.
All right, so that was the legal trivia for today, and that's it for our episode of A Question of Law. Now, I want to say a big thank you to you for watching, and then also to my guests, Selma Donu, who is a private legal practitioner, as well as Clement Kojo Akapam, who is also a private legal practitioner, as well as the senior law lecturer at Gimpa School of Law. Gentlemen, thank you very much.
Pleasure.
Right. And thank you very much for watching. My name is David Kwekuseche. Keep watching Citi TV. We'll see you next time.